Welcome to LegalBid, your fast pass for choosing legal help. The following video is for aggravated DUI, third offense DUI within 7 years or 84 months. As you know, the state of Arizona is extremely harsh when it comes to DUIs. In fact, Arizona is one of the few states that you can receive a felony DUI on a first offense of being pulled over under the influence. Before we start speaking about DUIs, let's cover some definitions. According to Arizona Revised Statute 28-101.24, driving means to operate or be in physical control of a motor vehicle, meaning you don't necessarily need to be driving for an officer to use that word. The meaning under the influence means that the person is under the influence of alcohol, drugs, medicines, vapors, any toxins, or any substance that impairs a person under the slightest degree. Typically, in the state of Arizona, there are 4 ways that a law enforcement can approach you to start a DUI investigation. First is a traffic violation, like driving too fast, running a red light, etc. Second is by a welfare check. An example of this would be a car crashed in the middle of the road or a car parked on the side of the freeway, etc. Third is by a complaint or by a third-party observation. For example, a witness calling 911 complaining that a person driving too fast or weaving in and out of lanes. Fourth is a DUI checkpoint. Once the individual gets pulled over, law enforcement will ask questions such as, "Have you been drinking tonight?" or "Where are you coming from?" hoping you will say from a bar or something incriminating. In Arizona, along with most of the country, you have the right to prevent criminal incrimination. Therefore, it is your choice if you choose to answer that question. If you give incriminating comments, or even if you admit to drinking a drop of alcohol, you are automatically opening the doors for a probable cause to believe that you are possibly committing a crime. Usually, if you incriminate yourself, the next step is doing some form of field sobriety test. Some type of physical test that an officer may ask you to do are the following: horizontal gaze nystagmus, eye coordination test, walk and turn, one-legged stand. In the state of Arizona, it is not required for an individual that is under investigation of DUI to take any field sobriety test. Other evidence that the officer can use are visual and physical observations, such as slurred speech, bloodshot eyes, lack of balance, smell of alcohol, etc. A portable breathalyzer test, PBT, is not admissible in Arizona, but in most cases, officers around the state have PBTs handy. If you submit to a PBT, and if you blow a degree of alcohol over 0.04 for commercial drivers and over 0.05 for everyone else, it helps the officer to justify an arrest for further testing. After the officer is successful on piling up evidence against you, the next step is an arrest. A law enforcement will arrest you temporarily and collect a breath sample with an admissible machine, such as an Intoxilyzer 8000 or 9000. They also have the option to take a blood test, 2 vials, or a urine analysis, or all 3 of them. If you are at this point, Arizona has a law that is called implied consent, ARS 28-1321B, meaning if you refuse to take any of these tests, your privileges to drive will be suspended or denied for a minimum of 12 months. Failure of doing the test correctly may also count as a refusal. The officer might also tell you that if you do not take the test, blood vials or urine test or Intoxilyzer 8000 or 9000, they can obtain a search warrant and force you to take it. If it gets to this point, it may turn a bit ugly. While you are arrested, they will ask you more incriminating questions, such as, on a scale from 1 to 10, 10 being the worst, how intoxicated do you believe you are? As stated before, you have the right to prevent self-incrimination. Typically, after they are done with their investigation, the officer will conduct an arrest and book you in. If an individual is driving under the influence, and on top of that they have 2 prior convictions for prior DUI violations within a period of 84 months, then that person is looking at an aggravated DUI F4. For this case, the state needs to prove the following: establish a reasonable suspicion for the pullover, establish that the individual has an alcohol concentration above 0.05 or is under the influence of drugs or anything that cause being impaired under the slightest degree, 2 prior DUI convictions within 84 months. According to Arizona sentencing guidelines, a first offense Class 4 non-dangerous felony may carry between 1 to 3.75 years in prison. But on a first offense, the person qualifies for probation. With an aggravated DUI, there is a minimum prison sentence of 4 months. According to Arizona Revised Statute 28-1383D, no one can lower, pardon, commute, or suspend the sentence. Minimum of 4 months is required. If the person charged has prior felony convictions, then sentences get increased depending on how many felony priors the person has. When it comes to finding the right attorney for a felony DUI charge, LegalBid.io gives you the power to choose by letting attorneys bid to represent you. Here's a breakdown of what you can expect. Option 1. Novice lawyer. Attorneys with at least 2 years of experience handling DUI cases are ready to help clients with straightforward cases. These attorneys are dedicated to providing cost-effective representation, with flat fees typically ranging between $6,500 and $8,500, trial costs excluded. Submit your case details and let attorneys practicing in your court jurisdiction bid to represent you. Option 2. Experienced lawyer. With 6+ years of DUI-focused experience, these attorneys bring extensive knowledge and courtroom exposure to their cases. They are well equipped to handle complex legal scenarios and offer an elevated level of expertise. Their fees generally range between $8,500 and $15,000, trial costs excluded. Post your case and allow these seasoned attorneys to bid on providing the representation you need. Option 3. Top-notch lawyer. For those seeking premium legal representation, attorneys with 10+ years of experience are available. Many of these professionals are board-certified specialists, bringing the highest standard of expertise and meticulous attention to detail. These attorneys are ideal for complex or high-stakes cases, offering representation tailored to each client's unique needs. Their fees typically range between $15,000 and $20,000, trial costs excluded. Share your case and watch as top-notch attorneys compete to represent you. Next steps. Your journey to finding the right attorney starts with sharing your case details on LegalBid.io. Law firms specializing in your type of case and court jurisdiction will review your information and bid to represent you. You'll have the flexibility to compare bids and select the attorney who best fits your needs, preferences, and budget. Take control of your defense today. Let the right attorney come to you through LegalBid.io. We trust you've gained more knowledge and will make the best decision from the available lawyer options. Each attorney, from novice to experts, aims to achieve case dismissal or obtain the best possible result with the least exposure possible. Best of luck, and may you have a great experience using our platform.